Hi, everybody, and welcome to the first week of your HRM program. This is Tom Cushing. Gave you a similar kind of presentation at orientation. We'll make that available on the website in case anybody misses it. But what I wanted to do today was to give you some background. I will do these narrated PowerPoints routinely during the course, usually during the cyber weeks. So this will be introductory material that I hope will be valuable to you as we proceed with the blending of the three courses. I will also do my best to improve my diction so I don't have to do as much editing on the closed captioning that I will include with these on a routine basis. I think that's just good practice. Next slide. So what I'd like to do with this presentation is to give you big picture considerations. The course approach. We will cover all the important legal elements of the employment relationship or the working relationships to include volunteers, interns, independent contractors, and employees. Um, and we will deal with issues like what constitutes at-will employment, how do we classify workers as employees versus something else, typically independent contractors. We will attend to all the many and ugly forms of discrimination that have led to legislative protection against them, as well as harassment. And we'll deal as well with labor management relationships, with the budding field of employee privacy, and with health and safety. So we will give particular attention to California rules because, following our theme, California will often be different from the general rule. The text should best be considered a resource. That is, it's a handbook that I think will be useful to you as you proceed with your careers. It is a good guide to specific problems. It doesn't give you quite as much context for why things are the way they are and what the structure of the system is, that kind of issue, that we believe would be valuable. So the objective in these presentations is to enrich or fill out your understanding of some of these topics in ways that we hope will be useful to you in your professional careers. Thus, this PowerPoint is intended to be important context. We will talk about the American legal system based on precedent, as I referred to in the orientation talk. Then we'll talk about the regulation of work, the nature of employment, why it's regulated, and what the federal and state agencies are which perform regulation in various ways that impact your enterprise from a human resource perspective. Then, because of its significance in the economy, we'll spend some particular time on employment at will and exceptions to employment at will. So let's get started. Next slide. Now, you will recall from your civics earlier in your academic careers that there are three branches of government: executive, by far the largest, that carries out the business of government, as well as legislative, which sets the rules, and judicial, which interprets the rules in real life fire circumstances, and also ensures that anything that the other two branches do is consistent with the Constitution, the formative document of our democracy. Now, when we focus in on the judicial system, as I indicated earlier, it is based on stare decisis, the thing decided. We have to use Latin occasionally. If we didn't, law school would only be 2 years instead of 3, and there'd be a lot more lawyers. You don't want that. So, stare decisis, or precedent, means the thing decided. Once a thing is decided, that rule ought to be followed in the future until there's a good reason not to follow it. So, precedent becomes the rule until it isn't, until a majority of an appeals court concludes that there is a better approach or a different interpretation that ought to be brought to bear. How do we know what precedent is? Well, when cases are appealed, the court that decides them issues judicial opinions, and these are collected into volumes online or in libraries that deal with the many and sundry subject matters of the law. Appeals courts operate by majority rule, so there will be a majority opinion, and that is the one that matters most because it applies the rule to, it states the rule and applies it to the dispute to determine who wins and who loses. A concurrence is a variation on that theme. It basically says, I agree with the outcome, but for a different reason. And this is, by definition, an opinion that couldn't command a majority, but it often brings interesting points into the debate. And so concurrences, as we will see in a couple of cases during the course of this term, sometimes point the way to a new rule down the road. And then dissents disagree both with the outcome and the reason why, and they state that as such. Dissents are also important as potential harbingers of future rules, that is, predictors of the way the law may go eventually. We will see. So each of the majority, concurrence, and dissenting opinions will be published and will be able to be referred to. Now, I've talked as well at orientation about the difference between liberals and conservatives in terms of their judicial philosophies. The combination of the two and the ebbs and flows between them really provides some balance between the stability you want in a legal system, which reduces risk in the society and especially in business, the predictability that provides, and evolution of the law as the society does grow, change, confront new issues, etc. So understand that that's part of why law is messy, is because it represents this tug and pull. And right now we've got a real tug of war going on between liberals and conservatives with the evolution of the administration, the executive branch, from the Obama administration to the Trump administration, and a retrenching of a lot of Obama era and earlier rules in favor of things that are of preference to the new majority. Now, when we look at the structure of the court system, you can think of an inverted funnel where trials start at the wide end of the tunnel, and the trial represents the 5% or so of disputes that actually get filed formally into the litigation system and actually get tried, that is, heard by a judge. Some smaller subset of those 5% proceed to verdict, and that verdict represents the application of law to the facts as determined by the trial court. Now, there is one appeal, right, by the unhappy person at trial, usually the loser, to ensure that the right rules were applied and that they are good rules. Note that we don't retry the facts on appeal. They are taken as found at trial because there's so much the richer array of observations that can be made live. So whatever the jury or the judge in a bench trial determines, those 12 people who couldn't get out of jury duty will be the fact record against which an appeal may be taken once by right, and then it is possible that a second appeal could be made to the U.S. Supreme Court. That, however, is not by right, but by what's called certiorari, more Latin. The appeals issues are, well, the structure of the system is that there are roughly 100 federal district courts that are broken up by states and areas within states, and then those funnel into 13 circuit courts of appeals, because a lot of cases are not appealed, and from there to one Supreme Court. So we are in the so-called Ninth Circuit in California. It is reputed to be a relatively, quote, liberal circuit as opposed to other circuits in other parts of the country, where the majorities of those judges tend to be more conservative. That said, the Ninth Circuit is also pretty influential because California is pretty influential, and a lot of the cases that the Ninth Circuit deals with do come out of our fair state. Now, what is certiorari? Certiorari is a grant of permission by the Supreme Court to appeal to it for a decision in a particular case. That is, you don't have an unfettered right to get there, but if the Supreme Court decides to hear it, they will grant certiorari and hear your case. What are the reasons to grant certiorari? There are two main ones. The first is that it's simply a very important situation that should be resolved for the good of the society. That is, there should be an outcome on this particular point of law. If we look at whether the Civil Rights Act of 1964 applies to the LGBTQ community, that is an important social question, and it's part of why they have agreed to hear that case. They may also agree to hear a case because there is a conflict between the circuit courts of appeals. That is, the Ninth Circuit might have one rule, and the Fifth Circuit might have a different rule, or the Seventh Circuit, which is renowned for its conservatism. You want to have one rule for the whole country, and so if there is a conflict, and coincidentally, in that same issue of whether the Civil Rights Act extends sex discrimination to LGBTQ employees protections, there is a conflict between two of the circuits. I think it's the Seventh and the Third. One has decided it does extend, the other has decided it doesn't. And we'll get into that in greater detail further down the road. Next slide. Now, the state court systems, same template as the federal court system in almost every state, and certainly in California. There are superior courts that are trial courts organized by county. They funnel into 5 appellate districts, and from there to the California Supreme Court. Same rules apply. First appeal by right, and the second appeal by grant of permission. Now, there is an interplay between these two court systems. First of all, you need to understand the hierarchy of law. Every law must be consistent with the Constitution as the formative fundamental document of the Republic. Uh, and so constitutions control statutes, those pieces of legislation that are passed by legislatures or by Congress and signed into law, and statutes control common law. Now, common law is simply judge-made law that a majority of judges in an appeals court has determined is a good rule to resolve a dispute between two parties. Maybe it's a rule of contracting or a rule of tort law or something else, but it was never passed by any legislature. It is simply a rule that has proven its value over time as a way to define the rights of individuals within the jurisdiction of the court. Now, there are constitutional claims that are made, and we will see a number of them in the context of this course. Most of them don't concern the structure of the Constitution, but rather the Bill of Rights, those individual rights as against the government, those checks on government power that constitute the first 10 amendments to the Constitution, plus the 14th Amendment regarding due process of law and equal protection of the law. Now, there will be some separation of powers issues, especially when you have an executive branch that is attempting to extend its influence into areas where it may not have the power to do so. And those decisions need to be made. And so, for instance, in this current controversy over the wall on the southern border, the question was whether the executive branch could take money that Congress had allocated for military purposes and divert it to build a wall on the southern border, not for military purposes. Question is, who has the power of the purse? And that so far has suggested that there is more executive power than many of us thought, but the final word is not in on that particular issue. But you see how these questions arise. Each branch of the government needs to, quote, stay in its lane, as is said, and so separation of powers cases come before the court. There's also the question of the Commerce Clause. The federal government only has power to regulate interstate commerce, and so you will see in every federal statute that we study that there is a lower limit to the size of the businesses that are covered. In the Civil Rights Act of 1964, if your business has fewer than 15 full-time employees equivalents, then you are beyond the power of the federal government. Now, that's more apparent than real because every state has its own Civil Rights Act, which takes those similar kinds of protections down to the smallest of businesses done within those states. But the question of whether the Commerce Clause allows the feds to regulate is an important one, and every federal statute we'll look at has some jurisdictional minimum, below which, if you have a claim, you are relegated to state law, and California has a lot of state laws. So, with regard then to statutory claims, if Congress has passed a law, then the court has to decide what it means and how it's applied. In one famous example, the then 9 old white men of the U.S. Supreme Court came to the conclusion that pregnancy discrimination was not the same as sex discrimination. They seem to have forgotten some of their biology, but they indicated that there is very little legislative history to govern what is covered by sex discrimination, and they just decided that if pregnancy was going to be there, it would have been mentioned, and it wasn't. The Congress came back the next year and passed the Pregnancy Discrimination Act to say, yeah, it's covered. And so that was an amendment to the Civil Rights Act, which the Congress was welcome to do. So you have this interplay between the legislative and judicial branches on the interpretation of statutes, where the court just comes to a conclusion and the legislative branch can vary it. And then in state decisions, if they are interpreting state law, state statutes and the like, then their view is final unless there is a U.S. Constitution issue that may have been where there may have been a violation. Now, U.S. Supreme Court decisions are final. Although Congress may change a statute, it may not change a constitutional provision. There is a very laborious and time-consuming process for enacting amendments to the Constitution for good reason. You want people to be able to rely on what the Constitution says. So there have only been fewer, I believe, than 30 amendments to the Constitution, the first 10 of which were passed at the same time the Constitution was ratified. Again, the states' rights people wanted to ensure that the new boss would not be the same as the old boss, to quote The Who. Sorry, I'm a boomer. Meaning that having just kicked out the tyrant King of England, the colonists were loath to substitute a strong central government without limitations on its powers. And those first 10 amendments are limitations on those powers. Okay, next slide. Okay, when we're talking about a particular claim, we will be talking about a cause of action. That's a right provided by the law for a party to sue for a remedy when that right is violated. And the vehicle of a cause of action is a complaint filed by the claimant indicating that a violation has occurred and requesting relief. Now, in order for a court to be able to grant relief, you have to provide it with what is called a, or more Latin, prima facie case, meaning on the face of it, this law has been violated and relief should be granted. So it is a presentation of evidence that addresses each element that needs to be proved in order for a cause of action to be sustained and relief to be granted to the plaintiff. So it demonstrates the claim, and if it is properly stated, it requires the defendant to answer in a document called the answer and defend against any such claims. Now, there are some significant pretrial pleadings that we will run into from time to time. There is the complaint and the answer. Those set up and frame the dispute. There's also a motion to dismiss, and that's where the defense claims that the complaint is somehow defective, that it doesn't state a prima facie case on which relief can be granted. There is also what's called the motion for summary judgment, where the defense claims that even if everything the plaintiff says is true, the defense still wins because the law is not what the plaintiff says it is. It's common for these to be filed in work-related cases, primarily because they're relatively cheap. You can probably get your lawyer to create a proper motion for summary judgment for maybe $10,000, maybe more, depending on the complexity of the case. But a full-blown trial on the issues related to the complaint could well cost $100,000 or more by the time you get through several weeks of trial. So it's a gamble. It's an attempt to say, look, even if everything they say is true, we still win, so please give us summary judgment and put this at an end. Now, summary judgments and motions to dismiss are appealable at that time, and we will see that a lot of these the cases we'll be dealing with are on appeal from a grant of summary judgment, and the appellate court has to decide whether the defense is right. So we'll run into these again and again, which is why I am bringing them to your attention. Next slide. Okay, so I assume we're back. I apologize for the air silence for a few seconds. It is also important that you understand, because we will run into them all the time, the important administrative agencies that deal with work. Now, why are there administrative agencies in the federal government, or the state government for that matter? Well, they are established to handle the volume of business that arises under a particular law, and they are intended to gain expertise in handling those issues. Now, in the case of work, there are almost 100,000 claims filed with the EEOC, discrimination-related claims, every year. If those were added into the dockets of the federal court system, they would be a tremendous burden on the system. So the administrative agency is set forth to handle those claims, to provide a first airing and filtering of those claims. We will see later on in the semester how a claim wends its way through the, in this case, the EEOC, because it is a set pattern established by law. But what you find is that nearly all, certainly more than 90% of those claims are finalized within the administrative agency, which dramatically reduces the burden on the general court system, and it provides expert handling. So the agency will come up with guidance, with rules that it uses, so that potential claimants and defendants can predict how the agency will come out on a particular matter, and that helps deter bad claims, frivolous claims from being filed. Okay, so there are administrative agencies all over the government, the EPA, the IRS, a whole range of other subject matter agencies, but the ones we will be focused on the federal level are the Department of Labor, which polices the wage and hour rules of the Fair Labor Standards Act, and safety under the Occupational Safety and Health Act and its sub-branch, the administration, OSHA, Occupational Safety and Health Administration. We'll also spend a lot of time on the EEOC, the Equal Employment Opportunity Commission, who has jurisdiction over the Civil Rights Act Title VII, which is that part of the Civil Rights Act of 1964 that deals with employment, as well as the Age Discrimination in Employment Act and the Americans with Disabilities Act. Any of those can give rise to discrimination claims that are first handled by the agency under what's called the doctrine of exhaustion of administrative remedies. If you're going to have one of these agencies, then you ought to require that everybody use it first. So in order to be able to go to federal court with an employment discrimination related claim, you have to have what's called a right to sue letter from the EEOC, basically saying we've reviewed this claim, we've come to a conclusion, and so this claimant now has the right to file a complaint in federal district court. Those complaints are heard at the trial court level, and that appeal is called de novo, because it's as if the agency's processes never existed. The whole case is tried all over again. Not terribly efficient, but an important right for all parties concerned. And then finally, we'll look at the National Labor Relations Board, which was set up by the Wagner Act in the 1930s to handle issues of labor management relations. Will there be a union that represents some group of workers? That process of deciding that is under the NLRB's jurisdiction, as well as the ongoing collective bargaining relationship, which includes strikes and lockouts, etc. There are unfair labor practices by each side that are possible and that are regulated and punished by filings before the NLRB. In California, primary agencies include the Department of Labor Standards Enforcement, which is a little like the Department of Labor. It enforces the California Labor Code as well as 17 so-called wage orders that are organized by industry. There's the DFEH, the Department of Fair Employment and Housing, which regulates claims of discrimination under the California Civil Rights Act, which is called the Fair Employment and Housing Act. There are other acts as well related to discrimination that are within its its jurisdiction. And then it's important that we know that Cal-OSHA exists and that there are rules that go beyond the federal rules for health and safety in California. We will become familiar with IIPPs, by the way, which is not part of the state of Mississippi, but rather an injury and illness prevention program, which every workplace in California must have, and it's the first thing the inspector will ask you about if the inspector shows up at your door, and it's a good idea to have one. Okay, next slide. Now, when we move from structure to regulation, question becomes, is all this stuff really necessary? Do we really need to regulate the process of work? Okay, this is the slide in the right order. Now, there is regulation of the employment relationship. The employment relationship is a contract that renews itself for some set period of time in some instances, but in most instances it simply renews itself until either or both parties decide that it's over. That's what's called at-will employment, and it is formally symmetrical. Either party can terminate the relationship without liability to the other party. But regulation has been brought into this normal freedom of contract situation when the Congress or the states or cities believe that employees are really not on equal bargaining footing with their employers. So, minimum wages, overtime rules, safety and health rules are all situations where the government has stepped in to regulate certain what we'll call minimum decencies of the employment relationship. Thou shalt not pay less than X, 725 on the federal level, heading for 15 on the state level. Or unionization. What are the rules that determine who may unionize and what kinds of rules ought to apply to the process of determining collective bargaining? The law may command that employers refrain from using certain criteria like race or gender to arrive at specific employment decisions. That is the essence of discrimination. And Congress sought to enact laws, as did the states sometimes before Congress, to place what those factors which ought to be irrelevant to the employment decision out of bounds in making important employment decisions, starting from hiring and going through training and compensation and evaluation all the way to termination. And then there are also, as we are about to see, exceptions to the at-will doctrine, which will vary by state. That is, most employment is at will, except when these exceptions apply. Is all this stuff really necessary? That's the question that was being asked in the bogus slide. Hopefully I'm asking it again. Yes. So, the opponent view, anti-regulation, is, look, we have faith in markets. Markets will encourage employers' rational behavior. After all, biased companies forego crucial talent, and so there is market pressure to make good decisions based on the merits. That employers have their own business, and they should have the freedom to make the maximum number of business decisions, including who should work for them. And at the end of the day, that this is a willing buyer, willing seller situation like every other contract. There are no victims. Well, the pro-regulation forces would beg to differ because there are very clearly victims. There have been, if you look at the history of employment in this country. So the proponents would say human beings are not often rational. That is, we are bundles of emotions looking for ways to express themselves, sometimes rationally, but often not. That there is an imbalance. Employers generally dominate employment relationships in terms of the prerogatives that they have. That discrimination as an institution is unjust. And it continues on both conscious and, as we'll see, unconscious levels. And it ought to not play a role in employment decisions. There are whole classes, categories of status situations that are victims of freedom of contract in the absence of these laws, whether it's individuals with disabilities or individuals by race or gender or sexual orientation or religion, all of which have a rich history of discrimination in American history. Next, that there are market imperfections and biased firms can remain competitive. You can look all over the economy to find them. And then finally, there is a notion of the social contract, that the best angels of the American nature stand for at least minimum decencies on pay, on safety, on benefits, on equality of opportunity, and that we ought to be encouraging those things via government action where the market has proven itself to be an imperfect arbiter. Next slide. So, now let's focus in for the remainder of the time, probably, hopefully less than 20 minutes, on at-will employment. At-will is an employment agreement where there is no legal obligation to continue for an agreed-upon time. The agreement renews itself for every shortest period that you can contemplate, and may be terminated by either party without liability to the other. So if you were halfway through producing those 100 widgets that you had been employed to make, and you decide to go do something else, you don't owe your employer the finishing of those widgets. Rather, the employer needs to go find somebody else to do it. Similarly, the employer may terminate the relationship, as you'll see in the next slide, for a good reason. You're incompetent. For no reason at all, you're left-handed, but just not, or that the economy dictates, but just not for a bad reason, and we'll go through those bad reasons as exceptions to at will. So it's theoretically symmetrical. In practice, not so much, where the most of the risk of economic downturns therefore devolves onto the employee. Now, there are, and in other economies, that's not necessarily the case. There are other types of employment relationships, like civil service in the government sector, the terms of a collective bargaining agreement, which can vary at will regulations, or individual contracts that define terms and duration. I teach under a contract for me to handle this course. In that, I share that and little else with pro sports contracts, where someone may be engaged to play for a particular team for a particular period of time. Next slide. So again, the key concept and the general rule: either party may terminate the relationship at any time for a good reason, no reason at all, including a lot of very stupid reasons. Under freedom of contract, you have the freedom to be stupid, but just not a bad reason, one that falls within these exceptions to the doctrine of employment at will. Again, most private sector employment is at will. Now, practically, most economic risk is borne by the employee. What that means in the very big picture is that businesses in the American economy can be quite agile. They can jettison workers with a downturn in demand. They can also hire them relatively quickly as demand improves, and those costs, those labor costs, are really part of the variable cost of providing the goods or services that the American firm produces. Contrast that with other economic systems, particularly in the EU, where once you have hired somebody, it's going to cost you a substantial amount of money to get rid of them when they are no longer in demand because of the business cycle or obsolescence of skills, or for whatever reason, incompetence. So recognize that in this economy, most of the economic risk is borne by employees. We are expected to be rugged individuals and go out and find our next job, and the business benefits from that flexibility. Now, there are exceptions to employment at will. They are functions of state law for the most part, and we will go over each of them in the next slide. The next slide is a summary, and then we'll look at each of them in some greater detail. Next slide. So, if you violate employment law, like race discrimination in hiring or retaliation against an employee for some illegal reason, if that motivated the employment action, like a termination or a failure to hire, that would be an exception to at will. You don't have the right to violate other provisions of employment law in order to be an at-will employer. You don't have that discretion. There is what's called a malicious termination that may violate public policy. There may be a breach of some other implied contract term, like a handbook term that limits the employer's unfettered discretion to get rid of people at will. Or in a few states, including California, because we're different, there can be a breach of an implied covenant of good faith and fair dealing. And finally, there may be a termination or an employment action that's in violation of the doctrine of what's called promissory estoppel. We'll look at each of these in greater detail starting now. Next slide. So the public policy exception is a legal concept that is intended to ensure that no person, including a corporation, injure the public or damage the public good. For instance, you're the environmental manager at your plant site, and there's a burp in the production process, and some methyl ethyl death chemical makes it to the river in violation of your permits. You may be required to make a report of that upset and that discharge to the appropriate governmental agencies. If your boss says you may not do so and fires you when you state that you will anyway, that would be a termination in violation of public policy. We want people to follow the law. If the boss says don't do it, that is likely to be a violation of public policy. There was another case that involved a quality control inspector who discovered that parts that he had rejected because they weren't properly constructed in the production process were being later incorporated into the aircraft that his employer was making. Well, this didn't happen to be Boeing, but it might have been, and if that happened, that would be a firing in violation of the public policy exception. If he can prove that he was fired because he brought up these issues. Now, there is a subset of this called whistleblowing, which is covered by various federal statutes. And like the Sarbanes-Oxley Act with regard to financial reporting and a series of other government procurement type contracts, situations, where if you report waste, fraud, or abuse, you are protected against being terminated for that reason. Now, if you're terrible otherwise, that doesn't protect you, but you've got to be able to prove that this is what caused you to be let go or demoted or paid less or whatever employment action was taken. Under the California Labor Code, if you have reasonable cause to report up your chain of command that there is a problem that constitutes whistleblowing, waste, fraud, or abuse, then you are protected even if you're wrong, as long as you had reasonable cause to believe that there was there was misjudgment or misuse of a process or product. The link I give you is to the notice from the Department of Labor Standards Enforcement that explains this law in greater detail. Next slide. There's also implied contract. It's an unexpressed contract term that's created by either the words or the conduct of the parties. Employee handbooks used to be so touchy-feely. Welcome to employment at Megacorp. We're a family here. We hope you retire from here, and we want you to work your entire career happily in our wonderful enterprise. There are courts who interpreted that kind of language as forfeiting the right to lay somebody off except for just cause. So now when you read an employee handbook, it is rather hostile. And right at the beginning, it will say employment at Megacorp is at will, and your employment may be terminated at any time, and it may even say something like, and we can hardly wait to do so. In other words, destroying any implication that the employer has given up the right to terminate an employee at will. Now, there could be other provable conduct that would suggest that the employer has voluntarily limited It's at will discretion. As HR professionals, you don't want these. You don't want these incidents hanging around. They are sloppy management, and it is a matter for you to train your people in ensuring that these implied contract terms don't sneak their way into employment relationships. In California, there is a further implied covenant of good faith and fair dealing, which is implied in every employment contract, where it simply says that both parties are obligated to act in good faith and fulfill each party's reasonable expectations. So the question here is really, did the termination demonstrate bad faith by the employer? The classic example is that your company has been trying to land this whale of a customer for many years and has promised a $50,000 bonus to anybody who can bring this client aboard. You're in marketing, you figure out how to do it, you bring the client aboard, but you have to be employed at the end of the year when the bonuses are paid in order for that bonus to be due. They fire you on Christmas Eve. It's pretty clear that you were fired in order to avoid the $50,000 payment that in good faith you earned. So that would be a demonstration of bad faith. Now, the danger with a doctrine like this is that it could grow so big that it swallows the at-will rule, and so it is very narrowly construed. Most risks do not qualify, and only a few states recognize this claim at all. California is among them. So it has to be pretty outrageous conduct that's not otherwise explainable in order to be a demonstration of bad faith. But this is a check on employer discretion to treat its employees with good faith and fair dealing. Now, it could also apply to the employee side. I just don't know of any examples where it did. Next slide. There's also what's called promissory estoppel. The prima facie case is the employer made a promise on which the employee reasonably relied to his or her detriment, and the court will enforce the promise. The issues that usually arise are how definite was the promise, and how much of a detriment was there, was reliance reasonable. To give you an example, you've got competing job offers and your boss says to you, look, I know our offer is a little less, but in 6 months, I promise that you will have a review and a raise that will take you above that other offer, and so we really want you to come. So you come, and at 6 months, there's a new boss, or 6 months, the boss forgets. This would be a case where promissory estoppel might apply. Again, as an HR professional, you don't want your people making these kinds of promises, but as an HR professional, you know it happens with a capital S. So the situation here, well, in one such case, there was a manufacturing company with facilities in Ohio and Florida. A woman came to the plant manager who worked at the Ohio plant, and she said, I'm dealing with domestic abuse at home. I need to get out. Can I count on a job in the Florida plant because of my good work here, etc., if I move to Florida? The plant manager said, I think so. I will look into it. The employee disappeared, reappeared in Florida asking for the job several weeks later, and the question was, did the plant manager in the Ohio plant promise the job, because there were no jobs available in Florida at that time. Was there a promise? No, there was really only a promise to look into it. And so there was not a definite promise. It was really not reasonable to rely on it, and her claim of promissory estoppel failed. It's a poignant situation. We want to root for her because she got out of a bad situation as far as we know under these facts, but promissory estoppel did not attach in that situation. These promissory estoppel situations are rare, and you need to train your managers not to make these outrageous promises that make your life more difficult. Next slide. Now, there are a couple of other kinds of discharge which are not medical conditions but rather terminations. Now, a termination that is in response to an employee exercising her or his rights provided by the law would be a retaliatory discharge. Almost all the statutes that we will study have specific provisions that forbid and prohibit anti-retaliation provisions, because after all, otherwise, why would anybody ever file such a claim? Because it could get you fired. What we also see, people being people, is that these things often go up. These kinds of claims go up during recessionary circumstances where employees are trying to hang on to their jobs and claiming that they were retaliated against, where they may or may not have been. But you do see a sine wave of these volume of these claims depending on the state of the economy. It tends to be countercyclical. There is also something called constructive discharge, and that applies when the employer makes the conditions under which the employee is working so unreasonable that the employee has no reasonable alternative but to quit. Now, those of you who have seen the movie Office Space will remember Milton, he of the swing line stapler. Instead of terminating his employment, the boss first puts him in the basement, then turns off the power, then gives him a flashlight and a fly swatter and tells him he's in charge of roach patrol. In these situations, the employer is hoping to avoid a potential claim related to a layoff, unemployment insurance obligations, those sorts of things, but it's illegal. The courts do require that the new burden be substantial. In the Poloni versus Albuquerque case, a woman who was a police officer and who had discharged her weapon carelessly on multiple occasions, including one fatal occasion, was assigned to remedial firearms training. She considered that to be a constructive discharge. It was not. It was a pretty reasonable thing to do, especially if you might end up in the line of fire. In the Nassar versus the University of Texas Medical Center, a doctor of Iranian extraction was subjected to a variety of work-related harassments related to her national origin in the wake of 9/11. She was not Saudi, she was Iranian, but she was treated as one of those Arabs and was subjected to outrageous and unreasonable behaviors in an attempt to run her off. She also filed a harassment claim, but didn't lose her right to do that because there was constructive discharge that she was subjected to. Next slide. Now, that concludes, in just short of an hour, our first one of these narrated PowerPoints. Next time will be our first live meeting. It will be taken up in significant measure with the classification of workers, especially as between employee and independent contractor, which is a huge issue, especially in the budding gig economy. We'll also talk about the tension between the fact that non-compete agreements in employment circumstances are unenforceable in California. At the same time, trade secrets are particularly important to be kept in an economy that relies on innovation, as this state's economy does. So we'll see how the state of California deals with the tension between these two elements, both of which are important. And frankly, the protection of trade secrets is far from perfect. There are, however, some things you can do. So with that, I will sign off. See you soon.